Act says nothing at all about the powers of arbitrators, which are to be derived from the agreement of the parties. Sure.
It certainly does not, sir, but only to determine when a case can be disposed of summarily, that is only when the claimants are trying to refer to CVR.
So you are asking us to draw sustenance from the principles?
Yes, sir. Certainly, sir. Secondly, the contention comes before the tribunal is whether the tribunal is empowered to dispose of a matter summarily. I'd like to draw honorable panel's attention to section 33 of the English Arbitration Act. If I may read out the provisions of the of section 33. Section 33 talks about general duty of the tribunal. In clause 1 it says the tribunal shall A. Act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent, and B. Adopt procedure suitable to the circumstances of the particular case, avoiding unnecessary delay or expense so as to provide a fair means of resolution of the matters falling to be determined. Honorable arbitrators, by virtue of section 33, it is clear that the arbitral tribunal has the power, and I'd like to actually add upon section 33. Moving on to section 34, clause 2, subclause H. It says procedural and evidential matters include whether and to what extent there should be oral or written evidence or submissions. Arbitrators are only for.
Also, please take 33 too.
Yes, sir.
The tribunals are comply with.
Yes, sir.
Please read it further.
Sure. 2 says the tribunal shall comply with the general duty in conducting the arbitral proceedings in its decisions on matters of procedure and evidence, and in the exercise of all other powers conferred on it.
Please get it.
Sure, sir. The point that we are trying to prove here is that by virtue of section 33 and 34, the tribunal is empowered to adopt any sort of procedures that that avoid unnecessary delay in the disposal of matters.
I am for the law of power. I want to know how you come to the conclusion that you should exercise that power.
Sure, sir. Coming to that, in the present case, sir, the claims by the respondents are completely unmeritorious, and the claimants shall, in their due course of the claims only, sir, they rejected the documents. The contentions. I apologize for that. The contentions of the respondents are completely unmeritorious and vexatious. How does that happen? So we shall be proving the same in our due course of arguments. Secondly, sir, arbitrator. Sorry, sir. Yes, sir. So we are claiming that we need an oral hearing. The only contention that claimants have is the oral hearing needs to be restricted and not a prolonged regular arbitral hearing that the arbitral's tribunal goes on.
So who's going to prove that part?
Sir, we itself. So they're
mixed, right? Whether we exercise this power under section 33, 34.
Yes.
You have to tell us why we should exercise that power.
Yes, sir. So
what is so wrong? Why is it that what they're saying doesn't need to be proved with evidence or
primarily because none of their contentions have merit in the
Tell us why you think that they don't have merit.
Sure, sir. If I could finish this contention and then probably come on the merits of the things. Secondly, we'll be covering why the contentions of the respondents are unmeritorious and vexatious in the first case. Secondly, sir, arbitrators and madam arbitrator, in the present case, if at all a normal, regular, prolonged arbitration hearing is decided to be taken on by the arbitral tribunal, the respondents tend to lose nothing out of it. In the present case, arbitrators, since it was a CIF contract, all the costs were borne by the claimants. As of now, there has been no payment for the goods that were supplied to the buyers. The cost of insurance, the insurance premium has been paid by the claimants. The cost of freight, of the entire travel was paid by the claimants. As of now, even if the fact sheet is still silent as to where the goods are, but since the goods form the subject matter of the present case, they cannot be disposed of by the claimants. As long as the as long as the arbitral hearings go on, considering the inherent vice of the material that has been in question, it's a steel coil. As long as the arbitral proceedings go, the material is going to deteriorate, and the
But have they not rejected they rejected your document?
they have rejected.
So the contractor isn't the cargo yours?
So the cargo is ours, but since the proceedings
How
are
the proceeding is related to that? They said I don't want the cargo. Obviously, they're not paying it.
the
They
tomorrow,
rejected it.
yes, sir. By the end of this arbitral proceeding, if the tribunal decides that all the documents that were tendered by the claimants are correct and the respondents are bound to accept those documents, then the goods shall need to be transferred to the respondents, to the buyers.
Not necessarily. No, there's a breach. You're claiming that there's a breach. See, the contractors come to an end. You're claiming damages. Are you asking specific performance?
No, sir. Even if in the case of damages, sir, coming to that, even if the award comes in our favor, presently the
Let's
condition.
say today we decide that we are not going to decide summarily and we will need evidence. You will hold that cargo for the next 1 year or 6 months.
At the end of the day, you are looking in damages.
Yes, sir.
If you're asking the respondent to take delivery of the cargo and pay for the value of the cargo, you're in this asking for specific performance.
Sir, even
Asking for damages which you are properly entitled to claim on the grounds that they are repudiated breach of contract. Then you are claiming only damages.
sir, that was an additional submission. Primarily, what happens is that the goods are at the risk of the sellers presently.
But it's over, right? You have said, they have said, I will not accept the documents.
Yes, sir.
Therefore, it's come to an end. Now it's your goods.
Yes, sir.
So what are you waiting for? Why is that argument that they are not going to suffer it? They don't want it to.
Sir, even in that case, sir, as long as the proceedings go on, the payment is going to be stopped by them.
But they will not pay anymore. They close. You treat it as a breach. You are now claiming damages.
Sir, even in that case, the damages are going to get prolonged. The primary contention is that.
But what I'm saying is, what have you done with the goods in the meantime?
Sir, the fact sheet stays silent about this thing. So I won't be in a position to answer about that present matter.
So therefore, what you said, they are not going to be prejudiced if there is some proceedings because the goods are not going to suffer because everything will be paid by them.
Yes, sir.
False true, that argument. Proceed.
Coming to the question wherein if the English courts have actually accepted the tribunals using their powers to have a summary proceedings or not, I drive your attention to the judgment in the Travis Cole restructured holding case, wherein a similar set of facts, the tribunal was approached by one of the parties to have a summary procedure. The award was awarded. In the present case, the other party moved to the court challenging the award on the grounds of the procedure being a summary procedure, and that is why the award could not be satisfactory on their part. The court, sir arbitrators and madam arbitrator, held that when the tribunal was, if I could just request for an extension of time. In the present case, when the court was concerning the question as to whether the tribunal exceeded its power by the Act, the court held that the tribunal does not exceed its power under the English Arbitration Act by virtue that the English Arbitration Act is wide enough to provide the powers to the tribunal to decide upon hearings, decide upon summary hearings.
Do you have some content of your cases that you're referring to?
The present judgment was.
Okay. What do you have to say? You said some time ago that the LMA applies.
Yes, sir.
So everything applies. I'm not just
Yes, sir. I'll be coming to that. In the present case, the LMA intermediate claims procedure by verbatim do not have a summary procedure rule in the present in themselves. But coming to Rule 11 in the LMA intermediate claims procedure, it provides for a procedure that is very similar to a summary procedure. It says Rule 11A says that There is no automatic right to an oral hearing, and only exceptionally will one be held. Subsequently, the Rule 11 goes on to say where the tribunal allows such a hearing, the time period for the entire sorry, the time period for the entire arbitral proceeding shall be limited to 5 hours of one working day, I mean, 5 hours in total, wherein both the parties shall be given 2 hours each for their oral hearings. That is also where the tribunal derives its powers from. Rule 11 is completely discretionary on the arbitral tribunal, but the claimants try to convince the tribunal that such procedure under Rule 11 can be applied.
Your argument is that we should decide this case entirely on the papers, and that as soon as your argument is finished, we should hear no more oral argument either from you or from the other side.
Certainly not, sir. We are just claiming that the time period for providing our arguments for both the parties shall be limited to 2 hours.
Is that relevant really?
Yes, sir. As I said, sir, as long as the proceeding, primarily because.
It's like right now you wanted 2 minutes more. If I deprive you for 2 hours and 10 more minutes, okay, is that relevant really? It's a discretionary part.
Yes, sir. Okay. The tribunal.
Tell us why you think it should be summary.
Sir, primarily because there is no merit in the present.
Keep saying that, but I want to know what.
Yes, sir. I'll come to that. I'll be dealing with the first issue on merits, on the substantive issue regarding the present case. That shall. The next issue that I shall be making my submissions on, honorable arbitrators, is the presence of transshipment and a scissor clause on the bill of lading, which, as claimed by the respondents, does not provide them a continuous documentary cover, and hence makes it a bad tender. If I may proceed with the submissions. Honorable arbitrators, the claimants contend in the present case that yes, there is a transshipment and a scissor clause present on the bill of lading, but that does not deprive the respondents of any sort of continuous documentary cover in the present case. By saying so, we claim that the insurance provided.
Why do you say so?
Sorry, sir.
Why do you say so?
Sir, because
you made a statement.
Yes,
sir. Support your statement.
Sir, coming to that, under a CIF contract, the need is that the sellers need to protect the protective buyer's rights of the buyers. In the present case, to protect the rights of the buyer, the insurance is provided. Even though in the present case, if at all the carrier invokes his transshipment and scissor clause and he transships the present goods, and even if he seizes his liability, whatever happens with the goods further, the buyers are still going to be protected with their goods.
So do you ask whether you simply deny that there is any requirement under a CIF contract for continuous cover as against the carrier? Because you appear to be trying to persuade us, and you may manage it, that if the goods are properly insured, that doesn't matter. But are there not plenty of cases saying that the bill of lading must provide a continuous right to see one carrier in respect of anything that goes wrong through the whole carriage?
Yes. When we talk about the right to sue one carrier, coming to that, sir, even if a transshipment takes place, let's call the carrier A as the first carrier in our present case, the goods go to carrier B. Under common law, if I could grant request for an extension, sir, under common law, the buyer is still liable to sue carrier B in that case, since the bill of lading gives a title document to the buyer.
Can he sue carrier A? That is surely that is the question that you have to persuade us of. Can the consignees here sue the original carrier if that original carrier transships the goods?
Sir, until and unless the goods are suffering any sort of damages, the question of suing the carrier does not arise.
So that is not the issue. The issue is they are saying CIF contract, you are supposed to have been giving me insurance which for continuous carriage. You have now given me a bit of lading. There is a chance of a great deal of lading where there will be two carriers, that the insurance doesn't cover, therefore you have not given me a document which is what I wanted, therefore I don't want it. So, the question that is asked is there a legal proposition that you have, a legal case that you have, which says that if A takes the cargo and issues a bill of lading with the assessment office, but in between a transshipment takes place and the cargo is damaged during that time, B, can the consignee with the bill of lading which only has the name of the first shipping company sue the first shipping company and claim the money? Am I correct?
If I may get back to you on the same question. The next condition, arbitrators, that the claimants have, is a bill of lading, even if I apologize, even if there is a transshipment, it does not hamper the continued documentary cover since the buyer is still protected by the insurance.
Continuous documentary cover. How do you answer that?
Sir, the purpose of a continuous documentary.
If you want to come back later. Hi.
Sure. Sir, even in case of transshipments, coming to the Marine Insurance Act under Section 59, I shall come to it.
English for instance.
Yes, the Marine Insurance Act of 19. I do.
Provided us a copy?
No, sir. I can provide the copy. Okay, sure. Section 59 says effect of transshipment and says effect of transshipment. It says whereby a peril insured against the voyage is interrupted at an immediate port or place under such circumstances as apart from any special stipulation in the contract of affreightment to justify the master in landing and reshipping the goods or other movables or in transshipping them and sending them on to their destination, the liability of the insurer continues notwithstanding the landing or transshipment.
Yes, but what you have told us is absolutely correct as a statement of insurance law. But the complaint of the buyers here is not that the goods were not continuously insured, but that there was no carrier who was continuously liable in respect of the loss of those goods. The buyers are complaining that there's no carrier's liability. They're not saying anything about the extent of insurance coverage.
So in that case, as I pointed out earlier, even if a case where a carrier A ceases his liability to exist and the goods are transhipped to carrier B, the buyer in the present case is liable, does possess the power to sue carrier B as well.
To put it a little bit differently, actually, what colleague is saying, it's not the poor insurer, it is regarding the carrier and the continuous coverage.
Yes, sir.
So perhaps your point you are making by referring to the Marine Insurance Act.
Yes, sir.
It's not strictly in that sense or in that context.
Sir, yes, answering to that, coming to that, under common law, a common carrier also is liable for
But that's not the CIF document that he asked. The document that he asked is a bill of lading, which is a contractual, because you know, once you endorse the bill of lading in favor of the buyer, then they have a right of suit, irrespective of common law. You have to show your own cargo. There's a lot of other issues which may come up. The simple fact is, he wants a title document for them to sue against the carrier A, whose name. Is that possible?
Sir, what is important here is for their right to sue a carrier, whoever is in charge of their goods.
No, but our point, I think you may have misunderstood it. Our point is that you have to have a continuous right to sue one carrier, not a right to sue one carrier or somebody else to whom that carrier may have entrusted the goods. They are different.
The concept being that there could be three carriers. But when they get the bill of lading, they see a name of a ship. They should be allowed to just arrest that ship or go against the owner of that ship without having to go into an expedition, find where transshipment took place, where did the damage take place. The transshipping ship may say, oh, if damage didn't take place with me, go to the next one. They should be able to go to one person. With that clause being there, have you given them that right to do so? And if not, do they not have a right to be able to say, I'm not going to accept it? And following from that, if you want to prove that no, do you not need to need witness evidence to show why? And in which event can you have a summary action?
Firstly, I would request for an extension of time.
I think our patience may be wearing a little thin. Are my brother and sister arbitrators happy to grant one more extension of time, but only one?
Sir, if there is a possibility of time, I could ask my secretary, my
brother said he's only one, so why don't you go waste the time and use it?
Sure. Sir, in the present case, we are trying to contend that even if the bill of lading does give the liberty to the carrier to seize his liability, the protective rights of the buyer are still protected, both under the insurance and when it comes to having carriers. Under common law, it is a principle that a common carrier is still liable for the holder of the goods. The bill of lading in the present case does give a title to the goods, and hence the buyers are still liable in case of any damage to the goods, either to unless and until the goods are in the custody of carrier A. Sorry.
Buyers are liable.
Buyers have the power to sue carrier A as long as the goods are in his custody, and then to sue carrier B when the goods leave the custody of carrier A to carrier B. With that, I shall conclude my submissions.
Greetings to the tribunal. I am Mr. Lucknow counsel for the claimants. I shall be dealing with the Ratho clause issue and the insurance certificate issue. Firstly, I would like to clarify some points that the tribunal had. So, primarily, why are we contending that there is no merit in the case of the respondents? Firstly, on the basis of insurance certificate. Now, it is settled principle that insurance certificate can be tendered under the IISTL terms as well. I am dealing with issues that he dealt with, clarifying some of the tribunal's terms, if there are requirements. Please. Yes. Further, I would like to contend that it is settled principle that insurance certificate can be tendered. Now, in the fact sheet, the issue that the buyers have raised is that the tender of an insurance certificate was not in accordance with the implied terms of a CIF contract. Now, the input terms 2020, they provide for that a certificate can be tendered. Even the Marine Insurance Act may say under Section 22 that the policies emerged, the insurance contract of insurance certificate emerged a policy, a certificate can be tendered. In the present circumstance, in the fact sheet page 3, we have incorporated in the fact sheet page 3 on the certificate of the insurance, we have mentioned a policy number. Further, on the bottom line, we say this certifies that assured is insured under and subject to the conditions of open policy. So the policy here is embodied, the contract of insurance is embodied in the open policy, and the certificate that we have tendered here essentially views the exact terms of the policy that we have, the exact terms of the policy of the open policy that we are, the protection that we are giving to the buyers. That is one case. So the buyer's condition that the certificate is not in according to the impact of the CIF is completely just to deny payment. Further, moving on to the second submission, according to the Ratho clause, I will be coming to the.
I'm wanting to get away from the insurance issue now, because we have one or two questions we'd like to put to you on that.
No. Yes, what I was trying to do here is I was trying to establish that there was no merit. I was going on the clarification. The tribunal asked my co-counsel and prove the merit, prove that the secondary has no merit.
I take it you're dealing with insurance and retro clause.
Yes.
So therefore, this is your submission on why there is no merit on the insurance clause.
Yes. In summary, I would deal with the for the insurance at length also.
You're going to deal with it at length.
Yes.
So why don't you start dealing with that?
Yes, definitely. As please.
Please go ahead.
Yes. So on the first submission for the insurance certificate is that under the INCO terms, insurance certificate is specifically mentioned. I would read the INCO terms. Definitely. Further, in a judgment, it was said that it was 1920 judgment. I would point to the judgment. The judgment specifically said that at that juncture of time, there was the Finance Act had not come into picture, and the Marine Insurance Policy Act had certain terms which required tender of policy, or that a certificate was not sufficient under Marine Insurance Act. At that juncture, one of the judgment said that the name of the case is on para 8 of Claimant's memo, para 31, page 8. Para 31, page 8.
This is the second page 8.
Yes. The Circuit Court of Appeals for the Second Circuit held that the tender was good. Distinction Scott and Scott and Co versus Barclay Bank Ltd. In that there an approved policy was expressly called for by the contract. As to the objection that such usage compelled the bar to take insurance without seeing the full terms, the court said the certificate at bar contains some of the terms of policy alike underwritten, and for the balance refers to the English law. I can say there is a misprint here. Now it is quite true that such a reference leaves much uncertainty, but can anyone say that it is less certain than the permissible latitude in the provisions of a policy which the seller might tender and the buyer must accept?
Do you have any comment on one case which I notice is absent, which is Diamond, Alkali and Bourgeois, which has stood for over 100 years, and where that's a case where Mr. Justice McCarthy in the High Court said the tender of an insurance certificate as against an insurance policy is not a good tender under a CIF contract unless there is specific provision. How would you deal with that decision? You may wish to persuade us that it is wrong, but I think you have to deal with it.
Yes, definitely. I would come to that point. That was one of the rebuttals from my side towards the respondents. On that particular issue, Diamond Alkali case has been 100-year-old judgment, 1920 judgment. After Diamond Alkali case in 1929, or I would point out in my submissions, para 35, Hartford versus DeMonkey. It is a case of 1929, which is after the Diamond Alkali judgment. It specifically mentioned that although on the last relevant part of the ratio.
Which paragraph is it?
Para 35, 4 line from the last. Although it had in earlier cases in England and in this country, that is the Diamond Alkali it refers to, this position was reinforced by this case by recognizing the transferability of the certificate and a right of holder to claim under it. First, the certificate is effective to fulfill its intended purpose in the hands of the holder. There seems no adequate reason to deny the sufficiency of the tender, of its tender.
Was the point ever raised in this question as to whether, in this case, as to whether the tender of the certificate was good tender? You're absolutely correct in telling us that there was a claim against the underwriters. But does this case deal with the question whether the tender of the certificate was itself good tender?
It was not read. I pointed to another case in the memo itself. in para 32, in Johnson and Higgins versus Charles F. Garrigos and co. It is a case of 1927, 7 years after Diamond Alkali. It held that it was held that in absence of a specific agreement to supply a policy.
May I ask which court decided that case?
This was decided by a UK court. I was not able to.
It was an American court,
Yeah.
was it not?
Look at your citation.
Yes, it was an American court. My apologies.
But this contract is governed by English law, is it not?
Yes, definitely.
Won't the 2019-20 case still not hold over the New York judgment?
It will hold. For it, I would like to point out to Michael Rich. It is a citation in the book of Michael Rich. I will just read it out for lordships. In this particular book, Michael will analyze the position after Diamond Alkali and the position after the amendments made by the Finance Act in the Marine Insurance Act. It says that the seller tendered to the buyer, if the position taken in the Diamond Alkali case was still the law, it would be unsatisfactory, especially where the seller has to break a bulk shipment effected under one insurance policy. Nevertheless, the sale contract itself may differ from the presumptive CIF position. And it is noteworthy that modern contract forms.
Can I just pause here? It says that it can deviate. Where is the deviation in this part? From what I understand, it's a simple CI contract.
Yes.
Just read what you just read one more time.
Yes. Especially where the seller has to break a bulk of shipment, nevertheless, the sale contract itself may differ from the presumptive CIF position.
Where is the departure from the presumptive CI contract?
The panel under the current Incoterms, Incoterms 2020, they specifically mention that a tender certificate is sufficient under a CIF contract. Incoterms are given by ICC. In the present case, that is in our case, what has happened is that to import Incoterms in the agreement of the parties, the port name, the Incoterm name, then the port name, and then the other must be specified. In the particular case, we have specified Incoterm, that is CIF. We have specified port name, that is Miami. In the fact sheet, when you mention CIF Miami, it is in accordance with the requirement of ICC to incorporate Incoterms in it.
I'm sorry, what is the reference of the ICC here, the International Chamber of Commerce?
The ICC has given the Incoterms.
Was this contract specifically stated to be subject to Incoterms 2020?
It's not specifically stated, but the Incoterms on the ICC website, they mandated that.
Look at your fact sheet. It says it's a simple CI contract.
I think why what immediately we are asking is that you must be conscious about the issue here. Then you come there, regarding the applicability of the issues you are raising. Please consider that.
Yes, definitely. So I would.
It is only CIF. So how do take help of these contentions now you are raising or your arguments?
On that particular point, even if CIF is not, the implied terms are not particularly taken into account, the customary practice in England or worldwide has raised that certificates are allowed. Now, Incoterms specifically.
Where you get that?
In Incoterms and
you read out something which says that the 1920 decision holds the law, but people can deviate from them by agreement.
yes.
Show me the deviation which is there in by agreement. Then one can go into the next step. If there isn't, then the Ratho says it's a pure CIF contract. It requires that the certificate, the document needs to be provided. The policy needs to be provided.
Indeed, but if I am permitted to read the entire paragraph, which talks about.
Read it, but I'm not stopping. But isn't the second sentence itself just after that the rest is irrelevant? Because it says that 1920 is still a good law, and says, however, there can be commercial complications, so you can deviate from that. unless you can show the deviation, is any of the rest of the paragraph of importance? If you think, please do.
Definitely, because the 1920 judgment has been made depending on the Insurance Act, Marine Insurance Act 1906, which was unamended. After the Finance Act came into picture and it amended the Insurance Act, Marine Insurance Act, certain provisions were removed which allowed this use of certificate under the Marine Insurance Act itself. So Diamond Alkali, in the presence that amendments have come, does not have a good law because the enactment itself has changed.
What you're saying is, if I can stop you there, that Diamond Alkali now should be regarded as wrong because it depended on the old provision under which an insurance policy could not be used as evidence unless a stamp had been placed on it. Because that is the relevance of the Finance Act.
Not just that, further I would like to point out to one specific para. For sale purposes, the document should also have to evidence the sum insured and the voyage covered. Both matters no longer required by the Marine Insurance Act for a document to be a policy that satisfies the CIF bar rights. CIF bar is right to know the terms of the cover. Now, I would further to make a contention here that since we have given a certificate of marine policy, marine insurance, yes, definitely. Page 190.
You can carry on.
I would further move with my submission that this certificate itself has the essential terms of the contract, essential terms of the policy. Now, if you look at the certificate, I would go to the introduction of the certificate. The certificate affords a policy number. Further, the certificate says that this certificate the assured is insured under and subject to conditions of open policy. Now, if we go to the terms of the certificate specifically mentions about the exclusions, the inclusions, the conditions to which policy is subject to, the average terms and conditions, the limitation of filing a suit under the certificate, and further it also talks about who is assured. Even if the name of the assignee has been left blank, the buyer has been named as a transferee under the assured. So further moving on, upon surrender of the certificate, which conveys the right of correcting any loss as fully as if the property were covered by any special policy direct to the holders thereof, and free from any liability for other premiums. Now, essentially, this certificate has all the terms that a policy must have, and by removal of the stamp, the requirement of stamp act, the requirement of having stamping, this certificate is going to act itself as a policy because essential terms have been mentioned. Further, it says that provided, however, that the rights of bona fide holder of this certificate for value shall not be prejudiced by any terms of the open policy in conflict with those of the certificate. Now, this certificate per se is essentially the policy for the buyer, because whatever the terms are given in the certificate will act as a conclusive terms on the open policy that the Southwest China Insurance Corporation is giving.
Substantial compliance.
Yes, the purpose of tendering a policy is for the buyer to know what exactly are his rights under the policy, what it has been what are the inclusions and the exclusions in the policy. Now, if all of those things have been complied with, and a certificate is assignable and transferable, even though the name of the assignee is not mentioned under section.
You carry on. I'm sorry, I was not making any comment.
Yes, definitely. Under the Marine Insurance Act, section 51. If I may read, under Marine Insurance Act, section 51, a marine policy is assignable unless it contains terms expressly prohibiting assignment. It may be assigned either before or after loss. Now, in this particular case, the loss has not occurred. We don't know the condition of the goods. Even though the name of the assigned is loss payable at or to have been left blank, this particular condition can be complied with after the loss has occurred. Even though 53 regions of marine policy may be assigned by endorsement thereon or in other customary manner. reading both.
That's actually very helpful and explains your position. I think my brother and sister arbitrators would very much like to hear what you have to tell us about the retla clause, as we notice that time is getting on.
Definitely. I will come to the point of retla clause. Now, the main condition of the point of retla clause is that the definition of clean bill of lading specifically states that if there is a notation as to the bad condition of the goods or rusted condition of the goods, then the bill of lading would be it would be an unclean bill of lading, and hence it would not comply with CM implied terms, which says that a clean bill of lading must be supplied. Now,
Incorporation of the retla clause in the bill of lading render it to be unclean bill of lading.
on that particular point, I would come to that. So, for under Hague-Wisby rules, which apply to the particular case, yes.
How do you make the bill of lading? Not paramount.
How does it apply?
There is the Hague rules, there is the Hague-Wisby rules.
There are two particular aspects how the Hague rules apply to this particular case. Firstly, about the conditions of carriage, a clause has been mentioned which specifically states that the bill of lading, that the contract of carriage is governed under, the contract is governed under English laws. Now, since a specific type clause has been mentioned, this is a draft copy. So, if any type clause is mentioned, then this is supposed to override the draft copy what is mentioned in the conditions of carriage. Further moving on, the general paramount clause says, I would first point out the clause B, trades where Hague-Wisby rules apply. It specifically
The rules don't apply here. Korea is not a party to the convention giving rise to the Hague-Wisby rules. So this is not a case where the Hague-Wisby rules apply as a matter of law.
Further coming to that, I have two submissions on that point. In para A, it specifically states that when no such enactment is in force in the country of shipment, the corresponding legislation of the country of destination shall apply. Now, under US has incorporated Hague rules to the COGSA. Further moving on, trades where Hague-Wisby rules apply. Now, since US is a signatory and it has incorporated those rules,
It's not a signatory to the Hague-Wisby rules.
it is signatory to the Hague rules.
To the Hague, I think that was what my brother arbitrator was pointing out.
Yes. So now here there is a conflict whether Hague rules under US COGSA will apply or Hague-Wisby rules under the clause mentioned above will apply.
Let's keep that aside for a moment. Have a look at the retla clause.
Yes.
Would you consider this clause to mean that carrier has expressed reservation about the condition of the cargo, that the cargo that was received was in perhaps in discredited condition? How do you construe the retla clause? What is your understanding of the clause? How will you interpret that clause?
Yes. The clause is very clear in its meaning. The term apparent good order and condition, when used in this bill of lading with reference to iron, steel, or metal products, does not mean that the goods, when received, were free from visible dust or moisture. So the carrier is specifically saying that they were not free from visible dust. The carrier does not use the word may. He specifically uses the word that it does not. So since
Does it mean
exactly, so
it goes slow? It goes slow there.
Possibly have rust or moisture.
indeed, I'm coming to that point only. The carrier specifically makes a representation that there will be visible rust or moisture. Now, in a steel,
What do you say? That there is visible rust or moisture, or there may be.
there is specifically there is.
And how is this a clean bill of lading?
I would come further to that point. In recent case, 2013 Sahoo Explorer case, under the retla clause was first used defined in Tokyo Marine case. In that particular case, it held that the term visible rust or moisture would apply to all kinds of rust. That is, a rust of superficial nature or a rust of deep nature. So,
Do carry on.
so in the Tokyo Marine case, it gave the can I get an extension?
Yes, please.
In the Tokyo Marine case, the clause was given ambiguous meaning, since it said that it may be deep rusting or it may be superficial rusting. Now, in steel cargo, superficial rusting is bound to occur. Even before the goods are in the transit from land to the port, the cargo may be superficially, which does not affect the merchantability of the cargo. Further, when the goods are loaded on the ship, if there is superficial rust and the carrier is specifically representing uh, that there is superficial rust, then the carrier under the COGSA, it becomes a prima facie evidence. If we apply the UK COGSA,
Is the UK COGSA applicable?
yes. Further, I would like to point out in Hollandia case.
How is the UK COGSA applicable?
We just discussed right now.
I was coming to that, but the second or the contention on that point was in UK.
Before you get to the UK, explain to us why COGSA, I think you're referring to COGSA 71. How does that apply to this case?
Under COGSA 1990, under the COGSA, it has said that the Hague in 1971.
1971, 1992, 1996, there are many COGSA. Which COGSA are you referring to?
1971, it specifically states that the COGSA has been given force of law in England.
Correct.
So whenever
With applicability, have you got a copy of the COGSA?
I have got a copy of the COGSA.
Why don't you please read section 1, read section 1, subsection 3.
Which act prevailing the legal right now?
Pardon?
Which act, as the prescribes here, is prevailing the legal right now?
Both of those acts are prevailing. The 1971 is under the 1992. The 1992 Act specifically says that any provision in the 1992 Act shall not supersede the Hague-Visby rules. The last section of the 1992 Act specifically states that it does. Can I read the copy?
Will you just read the 71?
Yes.
Section 1, subsection.
Which section?
Section 1, subsection 2 and 3.
I don't have the entire copy of the 1971 clause. I have the copy of the Hague-Visby rules.
No, you need the, if it's an enactment you are talking about, you have to tell me how it is enacted.
I have the copy of 1992 COGSA in it. I don't have the.
But 1992 COGSA only amended the provisions making holder of a bill of lading, etc. It didn't change the Hague-Visby rule provision. There was no new provision. They didn't bring the Hon'ble rule.
Yes.
The Hague-Visby comes in only through 71.
Yes.
In fact, 92 sort of amends the 1865 bill of lading, and it says that you have to be a consignee or whatever it changed to making it a holder of the bill of lading, also entitled to sue. Yes. Why don't you just give this? Can you just give this to me?
The provisions of section 1 and 2. In this act, the rules means the International Convention. Means the International Convention for the Unification of Certain Rules of Law relating to bills of lading, signed at Brussels on 25th August 1924, as amended by the protocol signed at Brussels 23rd February 1986.
I don't have that.
The provisions of rules, as set out in the schedule to this act, shall have force of law.
Now come to the next one.
Without prejudice to section 2 above, the said provision shall have effect and have the force of law in relation to and in connection with the carriage of goods by sea in ships where the port of shipment is a port in the United Kingdom, whether or not the carriage is between ports in two different states within the meaning of Article 10 of the rules.
In light of this, what do you have to say? What you just said.
In light of this,
What you just said a second ago, how would you answer my co-brother's question?
Indeed,
Where did the shipment start from and where did it go?
it started from Korea and it ended in US.
So what is the relevance?
But then under the bill of lading, we have specifically included English laws.
English law could have anything. It doesn't automatically bring every English statute to
It says
your aid.
where the Hague rules apply, where the Hague dispute rules apply, where it applies. It doesn't say it mandatorily applies to the instant case, where it applies. Therefore, if and when a circumstance does arise, then it will apply. That's what it means. I'll just ask you one question.
Yes.
Then the other thing you answer. Ask you a question. So have a look at the Ratho law, which you've already seen, obviously, and you have a look at the insurance certificate, the exclusion,
Yes.
where there's an exclusion of rush, oxidation, discoloration, wetting. If there is a claim under the insurance policy at the port of discharge by the buyer for rust, oxidation, discoloration, etc., how would you reconcile the Ratho clause with the exclusion in the insurance policy?
In this particular,
He lodges a claim under the policy for rust. The insurance company then denied it. Could deny it. How would you reconcile the Ratho clause with the exclusion clause in the insurance policy?
indeed, on that particular point, insurance are supposed to cover for risks. Now, the inherent vice in goods, it will lead to rusting. Now, in the particular case of steel cargo, moisture is not the concern. If it is not timber cargo, then the moisture would have come into picture. But since steel cargo is prone to rusting, the inherent vice cannot be covered. It is not a risk per se. It is a definitive provision. It is not a provision, it is a definitive.
What do you
Did you mark that? Did you mark that exclusion?
Yes.
What do you find that? Can you mark the language used there?
Excluding rust, oxidation, discoloration.
Yes. So that is been referred to because that is just below that all this physical loss of damage from any external cause. Below that, these specific exclusions are there.
Yes. Over specific exclusions, all risks may cover under it the act of God and every other thing.
But not inherent vice, that's what it is.
Inherent vice.
But if there is presence of rust at the time of shipment,
Yes.
and there is a claim brought for rust at the port of discharge by the buyer, giving the contract goes through, how do you reconcile the exclusion clause? That's the question.
In the exclusion clause, if the
But there is rust at the port of shipment, the insurance company, let's assume the insurance company is denying the claim.
in this particular case, the insurance company is
Go on.
in this particular case, the insurance, if it would have, so if this rust is because inherent vice of the goods, then the insurance will not be applicable because insurance cannot cover for something which is certain to happen. But if the rusting of the cargo is because of the negligence of the carrier or the seller, then both of them will be liable.
But in the hand of a receiver,
Yes.
because there is an issue and it's supposed to be clean, even if there is a little bit of rust on it, surely the receiver, the consignee, will get the advantage of the fact that they are now able to sue the carrier straight away.
Yes.
But with the presence of that clause and the nature of the cargo, as you say, are you not typically saying that this is a clause due? Because when you make a claim, please note that if it's rust, it's excluded and you're not able to claim.
Yes, in this particular case, the buyers cannot claim for rusting. Further, I would point out that
Has it not made it the bill of lading illogical and unclean bill?
No.
What's a clean bill of lading?
a clean bill of lading is something which does not have notation which qualifies it of apparent good order condition.
Right.
Now we come to a main submission. In this particular case, the qualification would be something which would rob the term apparent good order condition its entire meaning. So when the Tokyo Marine case described Ratho clause, it said that the rust is inherent. Rust exposed by the visible rust or moisture would be of all kinds of nature. That is superficial, which is bound to occur, and deep rusting. Now, after the advent of Saga Explorer, what has changed in this particular case is that it specifically mentioned. It's specific.
I think you may have, as I said to your learned friend, one extension and one only.
Indeed. On the particular case, the Ratla clause here, why does it not qualify the term good apparent order condition? I would first say a submission that it is a clarificatory clause, not a qualifying clause. A qualifying clause will make a bill of lading unclean. Now, the difference between a qualifying clause and a clarifying clause is that the apparent order and condition by virtue of Ratla clause and reading Saga into it specifically states that the carrier is mentioned, that the master of the ship has made a representation that the bill of lading is the condition of the goods at the time of shipment is superficially rusted. Since that particular representation has been made, it is a conclusive evidence against the carrier and the shipper. And if it is a conclusive evidence against both of those parties, now they cannot go back. Now they are liable for if any rusting occurs afterwards.
But what about my claim against the ship owner? You keep bringing us back to these documents give us certain rights.
Yes.
Give the buyer certain rights against third party, not you. You go bust. You sell them the cargo, take the $1 million, NCLT bust.
Yes.
Now I've got this cargo which is damaged. What is my recourse? Is insurance says no, rust is excluded. But I can go after the ship owner to claim from the ship owner because he has issued a clean bill. But he will say, look, I've qualified. You can't come and sue me. Therefore, that makes the bill of lading not clean.
No, in that particular case,
can I sue the ship owner or not?
yes, you can indeed do
Because till now you just said I can sue you, but can I sue the ship owner?
Yes, indeed.
How?
Because
if the clause is there. You just said that the clause clarifies that look, there's a representation made so far as the carrier is concerned by the shipper that there is rust, and by the carrier also that there is rust. Therefore, the buyer cannot come after we can't go beyond that. If it gets more rusty, you can come after me. But if it is rust, you can't come after me.
yes,
Because you're buying it with knowledge of the rust.
yes,
Then I've been deprived. I bought steel, clean steel. The bill of lading should assess steel. If it qualifies it, then it becomes unclean. And therefore, my chances of getting anything from the owner because of that issue disappears.
in this particular, it won't disappear because the buyer, when the documents are tendered the ship, the condition of the goods is specifically mentioned. Now, since the condition of goods is mentioned, if there is any further deterioration or extreme deterioration which leads to extra rusting, then it is definitive that the condition of goods was not at the time of shipping. So it was not the same time of shipping. There must be liability of the carrier in that particular case. And if there's inherent vice, then
otherwise to apply the Hague or the Hague Disney rule, as you said, apply, and there's an exclusivity for that. Carrier is not responsible for the
yes, the carrier is not responsible in inherent
How
vice.
does he claim from the carrier and how does he claim from the insurance company?
Because
No man's land.
when we have shipped the goods on board of the ship, on board essentially means that the ships are not on deck of the goods are not on the deck of the ship. If the goods are not on deck, that means we have taken sufficient care for the goods to be in minimal contact with the moisture that is in the sea. Further, if the goods, by the inherent wise, the goods would not deeply rust in a year. For deeply rusting of steel cargo, it would take at least few years.
Where do you get all this information?
This is even Sahoo Explorer. It is a common knowledge that steel cargo will rust, but
So again, you need to leave evidence, right, on this. So can you have a summary judgment because of this?
I would further come to the point of that.
I think we're going to have to stop you in 1 minute, out of fairness to the respondents.
On this particular issue, the contention is that if the carrier and the buyer are stopped, if they are stopped from denying what they have mentioned in the bill of lading, then it won't become it won't become a qualifying clause. If the mere presence of the red flag clause,
You finish, you got 45 seconds. Now deal with the final point which you were saying that you were deal with on why summary suit.
on why summary suit. Yes, particularly on this issue, we have proved that the bill of lading is unclosed. Now, if you have proved that the bill of lading is unclosed and if it is a clean bill of lading, then the buyer is bound to accept the bill of lading. Now, further going on to the issue of the transshipment, if the claimants have particularly proved that the document cover is available, by virtue of the bill of trading or by virtue of the insurance, if the documentary cover is given to us buyers, then they cannot reject the goods. So on this particular issue, if the clauses, if the interpretation has been rightly given by the sellers, then on the summary basis, the case can be decided.
Are you saying specific performance only damages? Because have a look at your player.
Yes.
Player is not go.
I think we shall have to say thank you very much indeed for your extremely helpful submissions at this stage.
Indeed, may I answer the co-panelists?
Very, very briefly, please.
Yes.
The buyer be directed because of the consideration and accept the bid that you asking for specific performance.
This is an alternate limit that we are asking for. If the damage was not given to us, at least not a specific performance. If the trivia comes to a conclusion.
Thank you.
Much obliged. May I move the prayer clause or?
Not necessary. Not necessary. You read it.
Much obliged.
I think we have a book for you. Well, gentlemen around there might care to. Thank you very much.
2 minutes.
and the issue relating to summary disposal of proceedings. Next, I would discuss the substantive issue of retla clause. I would also be mirroring the arguments presented by the claimants and at the same time rebut them. The first issue is that the arbitral panel shall consist of a sole arbitrator as per Section 15 Clause 3 of the English Arbitration Act 1996. Arbitrators, I humbly submit before this arbitral panel that the mutual intent of the parties in the present case was to apply the English Arbitration Act. I request you to refer to page number 2 of the note proposition, in which the arbitration clause contained in the contract of sale has been mentioned. It has been mentioned that the terms of sale were CIF Miami, and the contract contained an English law and London arbitration clause. Arbitrators, this is an agreement based on party autonomy, and it is expressed. Therefore, English Arbitration Act is the forum of choice in the present case.
It's an oral contract, and if it's an oral contract, it's not in accordance with the provisions of English Arbitration Act, which require the contract to be in writing. So how would the Arbitration Act 1996 apply in the existing case, and also how would Section 15 apply?
Mr. Arbitrator, in the present case, there is an ambiguity as to which procedure shall apply to the arbitration proceedings. In the clause, it has been given that English law and London arbitration clause with any arbitration to be governed by the LMA rules. In such a case, there is no express choice in the agreement, but at the same time, according to the case of Sur America, an implied choice with regards to the law of seat pertaining to the arbitration agreement would apply in the arbitration proceedings. Therefore, in the present case, the seat of arbitration is England, and therefore the English Arbitration Act would govern the arbitration proceedings. Further, according to Section 2 Clause 1 of the Act, the provisions of the Act apply when the seat of arbitration is in England. Hence, the English Arbitration Act continues to apply even after adoption of institutional rules. Lastly, if no express choice is given in the arbitration agreement, the agreement would be found to be most closely connected with the law of seat in the arbitration agreement. Therefore, it is contended that since England is the law of seat in the present matter, Section 15 Clause 3 of the English Arbitration Act will determine the number of arbitrators which will be won in the absence of any agreement.
I don't think anyone is contradicting what you're saying about that. A brother arbitrator has pointed out that the agreement wasn't in writing, which is, I think, one way you have it some difficulty. But furthermore, is there not a clear case, even if the Arbitration Act applies, of a contrary agreement? If you and I agree on the LMAA terms, and the LMAA terms say 3 arbitrators is the default choice, how can there not be an express agreement here ousting the provisions of Section 15 of the 1996 Act? I'm sorry, I probably haven't made that as clear as I should.
Arbitrators, I understand the concern put forth by you. Firstly, I would just like to mention that there is a mutual intent on part of both the parties in the arbitration agreement to enter into to apply English Arbitration Act in the present contract. Furthermore, the ambiguity present in the arbitration clause relating to the provisions that would be applicable in the proceedings justify the application of English Arbitration Act.
It's very clear. The section says unless otherwise, and you agree to an term which provides for appointment of arbitration.
Mr. Arbitrator, there is an inclusion of both the provisions in the arbitration clause. There's an application of English law and London arbitration clause, but at the same time, it has also been given that it would be governed by LMA rules. That is why the council is arguing that there is an ambiguity as to which provision would be applied in the arbitration proceedings.
Are you not following LMA rules for everything else? Are you giving the LMA rules a complete go by?
Mr. Arbitrator, I would like to contend that even if we accept that LMA terms are applicable in the present agreement, we do not have to choose between the absolutes of choosing one procedure for the proceedings. Just because we are agreeing to LMA terms in the present proceedings does not mean that we also agree with the provision governing the number of arbitrators.
We can choose. We can choose. You've agreed to a rule, you follow the rule. The act actually says that it's party autonomy. If parties have decided on the rules, then the rules will. And as pointed out by the claimants, these are not mandatory rules. So why would you say that LMA is not applicable?
Mr. Arbitrator, the respondents are not claiming that we would pick and choose a particular provision from the terms. We are simply claiming that we do not have to choose the absolutes of the procedure. What I mean by that is, on the LMA terms website given online, there is a provision. Please give me 5 seconds to refer to the same. A sample arbitration clause has been given on the LMA website. In it, it has been stated that when the parties do not agree upon the number of arbitrators, the clause can readily be modified. In the present case,
Also, we're not dealing with the standard clause. You just said LMA rules to apply. The LMA rules specify how many numbers of arbitrators there will be. Simple. Why are we getting into something which has not been agreed?
Mr. Arbitrator, it is imperative to understand that the mutual consent of both the parties and mutual intent to apply LMA terms was not present in the arbitration agreement. Furthermore,
so you're saying LMA terms is not included?
Mr. Arbitrator, there is an ambiguity as to what procedure would be applicable in the arbitration proceedings.
You take a call. Are you going to follow LMA or you're not going to follow LMA? Is there an agreement to LMA arbitration or is there no agreement to LMA arbitration?
Mr. Arbitrator, the issue at hand deals with the number of arbitrators that are supposed to be appointed for the arbitral panel.
Part of whether you choose the rules or not. Because if that is the case, then you're arguing that you're picking and choosing a rule.
For this particular issue, we would like to contend that LMA terms do not apply, and therefore we would like to appoint a sole arbitrator under the English Arbitration Act. For the same, I would also like to contend that the sole purpose of arbitration is to give parties party autonomy and to instill mutual consent. If the same is not followed in the present proceedings, the parties would have a right to challenge the award given by the arbitral panel under section 68 of the English Arbitration Act, and that would go against the basic purpose of arbitration proceedings. Therefore, in order to uphold the nature of arbitration in the proceedings, it is imperative that we apply section 15 clause 3 of the English Arbitration Act and appoint a sole arbitrator for this panel.
I'm worried about, if you are right, and you may manage to persuade us that you are, if you are right, then in any case where I agree LMAA arbitration terms, and I want 3 arbitrators, I have to say LMAA terms and 3 arbitrators, even though the LMAA actually says that the default position is 3 arbitrators. Is that not a somewhat demanding position?
Mr. Arbitrator, a provision to appoint a sole arbitrator, as earlier argued by me, can be modified in the arbitration agreement if there is no mutual consent between the parties as to the number of arbitrators that need to be appointed. Furthermore, in the present case, if we think logically, there is an arbitration.
Maybe for your co-presenter also, you have to think in these lines that whether you should take this head on, that you never agreed. And you must also think that because once you propound that theory, then just now you yourself said that you will go in appeal, all that. All those complications you have to answer.
Indeed, Mr. Arbitrator, I understand the concern raised by you. I would just like to contend that there is a lack of mutual intent between the parties because in the present case, there is an arbitration clause given in the bill of
I have mutual intent to go for LMA clause.
Indeed.
That's your contention.
Indeed. Indeed, Mr.
Okay, carry on. You carry on.
The mutual. I'm sorry. Indeed, Mr. Arbitrator. There is an arbitration clause given in the bill of lading. Indeed, Mr. Arbitrator. Mr. Arbitrator, I am not saying that the arbitration clause given in the bill of lading would apply. The clause given in the contract would definitely apply to the case. From this clause, I want to convey the lack of mutual intent between the parties because
It's a different contract. We are not really interested in that contract. It doesn't apply.
I understand.
Keep bringing other clauses, the NLUO clause, this clause. Talk about your clause. Give us clarity on your clause. You made a statement that section 68, 69, if there was three which provisions of 68 or 69 you take it up in appeal?
Indeed, Mr. Arbitrator. Section 68, clause 2, subclause B of the English Arbitration Act allows the parties to challenge a particular award given by an arbitral tribunal if the tribunal ends up exceeding their power, which would lead to enforcement issues in the present case. Mr. Arbitrator, indeed, Mr. Arbitrator, the provision applied under the English Arbitration Act allows us to appoint a sole arbitrator in absence of any number of arbitrators decided between the parties. Therefore, if three arbitrators are appointed, it would lack merit in the award given by the tribunal, and the same can be challenged by the respondents. Indeed, Mr. Arbitrator. Coming to my next issue, the tribunal shall not take an early opportunity to dispose summarily of the case. In the present case, the parties have entered into a commercial deal. If you may please refer to page number 2 of the moot proposition. If I may read it for you. The claimants, a Korean corporation, agreed by telephone to sell about 225 metric tons of steel coils to the respondents in the USA. This is a large size of cargo that is supposed to be transported from South Korea to the USA. The present case deals with a CIF contract, and the CIF contract is primarily a sale of documents and not a sale of goods. The documents tendered by the claimants are the basic evidential documents exchanged in a marine journey in a CIF contract. Any inconsistency with such documents will lead to a bad deal. In the case of Brandes versus Venezuela, the tribunal decided that the claimant's case is not susceptible to summary dismissal since it presents two complex legal and factual issues. In the present case, there is a substantive value involved and huge monetary credit. The issues that have been recognized involve complex problems related to the insurance certificate and the bill of lading, which require extensive discussions and deliberations and cannot be disposed of summarily.
Are these not entirely points of law which we can discuss here and now? Surely there is no actual evidence to be left. Why should we waste everybody's time, with the greatest respect to you, discussing matters which we can decide quickly now and thereby promote the aims of arbitration?
Mr. Arbitrator, in the present case, I would just like to answer that by saying that in the present case, neither the contract between the parties nor the English Arbitration Act provides for summary proceedings. And it is a general practice that arbitrators act beyond their powers in using summary procedures when the same is not provided in the summary procedure decided between the parties. Therefore, if summary proceedings are applied in this particular case, the arbitral tribunal would be exceeding its powers, and the award would again be would lack merit.
Do you have any authority which says that arbitral tribunal cannot exercise jurisdiction to have a summary trial?
Indeed, Mr. Arbitrator, in the case of Claimant versus Metaland, it has been held that the arbitrators act Claimant versus Metaland. Mr. Arbitrator, the same has not been given in the compendium, but it has been mentioned in the in the memorial submitted by the respondents.
Which page?
Mr. Arbitrator, the council is not aware of that fact.
Which page are you?
Please, paragraph.
Can I please get 5 seconds to answer the same?
Is it page 4? Page 422.
Just indeed, Mr. Arbitrator. Footnote number 22.
Can Metaland, is that the one that's only reported, sort of not quite reported in Westlaw?
Indeed, Mr. Arbitrator, but the same has been reported in a lot of other cases which state the same. Therefore, it would have a high.
Please read para 12 actually. What you want to highlight there? Basically, the question from the colleague is that see, it is equally beneficial to you for go for the summary. But what you are saying, occur and discover a substantial injustice when summary proceeding were allowed under LMA rules.
I'm sorry, Mr. Arbitrator, can you
Please
please?
read that that page 4 where you have referred to 22.
Yes, Mr. Arbitrator.
Para 12 you have referred there.
Indeed.
I will simply do 5 seconds also. Please. Anyway, please carry on.
Mr. Arbitrator,
That may not answer that query because unless you show that there was a substantial injustice or some proceeding were allowed.
Indeed.
But here we did not go there actually. We are not going there.
In fact, your sentence here on the law says, in the case of BTC, irregularity had occurred, and this caused a substantial injustice when summary proceedings were allowed. Is that what the judgment holds?
Indeed, Mr. Arbitrator.
Where is that judgment?
The same has not been given in the compendium.
BTC is again 20. Yeah, 20. That's an English judgment.
You said there were 2 points. One is quantum. And what's the second point?
Quantum of what, sir?
For not having a summary judgment. So there are 2 reasons.
Indeed.
One is that if the quantum of the claim is very large, then the arbitral tribunal should not decide this issue summarily. What's the second point?
Mr. Arbitrator, there are actually 3 points. The second point was that the test of manifest lack of legal merit in the respondent's case has not been fulfilled because, again, going back to the point that I mentioned before, the documents involved in this case are basic evidential documents that are exchanged between a buyer and a seller. If the same are not consistent with the agreement, if the same are not valid under law, there would be a detrimental effect on the case of the respondent, and that would infringe upon the rights of the buyers. Third point was that the right to be heard of the respondent would be affected if the case is summarily disposed. Under sections 33 clause 1 of the English Arbitration Act, it is provided that the tribunal shall give
Welcome to the 10th edition of the National
opportunity of presenting his case and dealing with that of his opponent, and anything contrary to that would not be valid. Therefore, it is contended that if the buyers are not allowed to deliberate over the imperative issues given in the present case, then that would lead to a violation of their reasonable right to be heard. If the arbitral panel does not have any queries, I will be moving on to my next issue, in which I would like to submit that the bill of lading, in view of the letter clause typed on it, was not a clean bill of lading and hence a bad tender. Before going to the crux of the issue, I would just like to mention that the test of cleanliness is an assessment that assumes that the goods were shipped in good condition upon inspection, and the same is not, and no evidence is provided to prove the contrary to it.
Is there any remark in the fact which suggests that the cargo was being through the carrier in damage or misleading condition?
Mr. Arbitrator,
The language suggests that the carrier or the shipowner is attempting to protect himself from any possible claim being brought for us on the premise that the bill of lading doesn't contain any adverse notation. These are the conditions of the cargo.
Mr. Abhichita, the regular clause given in the present case cannot be seen independent of all the other notations that have been mentioned in the bill of lading.
What are the other notations that you're referring to?
If the arbitrators may please refer to page number 7 of the moot proposition. If I may read it for you, are the arbitrators with me? The bill of lading states that the goods have been shipped in apparent good order and condition. This has been stated in the bottom right corner of the bill of lading. I would like to argue that a deadlock clause cannot deny the same. According to Copco Steel case,
No, actually, you have to go to the deadlock clause to mark it. So the question is whether inclusion of the deadlock clause at all makes it unclean.
indeed, Mr. Arbitrator.
Therefore, the language used in the deadlock clause.
Yes, Mr. Arbitrator.
Because as the colleague suggested that, why does it say
Mr. Arbitrator, the deadlock clause interprets
that the goods are submitted or goods are there with certain defects or certain damages? It doesn't say so on the face of it.
Mr. Arbitrator.
Well be that there is actually no rust or no moisture on the car. It very well be. Language seems to suggest he is attempting to protect himself.
Mr. Arbitration, since there is a paucity of time, can I please ask for an extension? Mr. Arbitrator, the term given in the deadlock clause, that is apparent good and order and condition, has been interpreted in the same, where it has been given that when used in this bill of lading with reference to iron, steel, or metal products, it does not mean that the goods when received were free of visible dust and moisture. With arbitrators, in the present case, in the bill of lading, it has been recorded that the goods were shipped in apparent good order and condition. But at the same time, it has also been mentioned that the condition of the goods was unknown. This creates an ambiguity.
How do you get there? It is unknown. Not that. Actually, the language is not that.
Mr. Arbitrator, if you may please refer to page number 7 of the moot proposition. It has been written that weight, measure, quality, quantity, condition, contents, and value are unknown. Therefore, with the presence of both these provisions in the bill of lading, this creates an ambiguity for those.
Actually, you are trying to interpret deadlock clause with help of this, or you are interpreting the deadlock clause alone.
Mr. Arbitrator, the term apparent good order and condition, which has been mentioned at the back of the bill of lading, has been interpreted in the deadlock clause by the carrier himself. It has been written that the term apparent good order and condition when used in the bill of lading, and the same has been used at the back of the bill of lading. Therefore, the existence of these provisions, where it has been stated that the goods were shipped in apparent good order and condition, while at the same time the condition of goods is unknown, creates an ambiguity for those who would rely upon the contents of the bill of lading. Also, a clean bill of lading has been issued by the carrier, omitting any kinds of defects in the goods that might be covered under the deadlock clause.
Excuse me, can I stop you there? If someone ships steel coils which have superficial rust and moisture on them, are those steel coils defective? I think you may have some difficulty persuading a group of hard-headed business people, which of course this arbitral board is, that is the case.
Mr. Arbitrator, it is imperative for us to understand that in the present case, we are dealing with a CIF contract, which is primarily a sale of documents and not of the goods. In whatever condition the shipper might sell the goods, the documents that have been tendered by them contain a lot of inconsistencies, and the same has been chosen as a reason for the by the buyers to reject the documents.
But having said that, you're in the trade, you are in the trade of steel, you are unknown to the trade of steel, and you are buying steel coils, which you know as a superficial rust. As soon as it comes out, within minutes, the bill of lading is otherwise clean. And the steel coil is not, rust is not interior. It only talks about the superficial outside rust, which is part of the trade. Does that make the bill of lading unclean?
Mr. Arbitrator, in the present case, visible rust and moisture has been excluded from through a DECLA clause. It has been held in a number of cases that light atmospheric rust or superficial atmospheric rust can be excluded from a DECLA clause. But at the same time, in the case of Saudi Explorer, it was said that heavy rusting cannot be excluded from a DECLA clause. And the same has not been defined in the DECLA clause or anywhere else in the bill of lading, and that makes the whole document inconsistent with the terms of the CIF contract. Furthermore, one of the purposes for stating what conditions the goods have been shipped in is to enable the ownership of the goods to transfer to the buyer while they are in transit. Any misstatement in the bill of lading might cause a loss to the transfer.
Are you saying you don't get title to the goods through the Sale of Goods Act? And only the bill of lading gives you title?
Mr. Arbitrator, in a CIF contract, certain documents need to be tendered by the claimant, which, when accepted by the buyer, transfer the ownership of the goods to the buyers. Therefore, the condition of
The bill of lading itself doesn't transfer the title.
no, Mr. Arbitrator. As I was mentioning, any misstatement in the bill of lading might cause loss to the transferee who pays reliance upon the contents of the bill of lading.
Who are these transferees other than your clients who would be disappointed to learn that steel coils they had bought had superficial rust on them when shipped? Your clients seem remarkably demanding of their sellers.
Mr. Arbitrator, may I please get an extension? Thank you so much.
You may have one more.
Okay, thank you so much. Mr. Arbitrator, since it is a CIF can you please repeat your question? I'm really sorry.
I had a comment, I'm sorry, carry on.
Can you repeat your question?
The question, he wants to repeat the question. Please repeat it.
I'll repeat it. Your client appears to be about the only buyer of steel in the world that we know about who would be disappointed to learn that steel coils shipped to them had superficial rust on them at the time of shipment. Does that not mean that your clients are being too demanding?
Indeed not, Mr. Arbitrator, because under a CIF contract, the documents that are tendered by the claimants involve a basic evidential value to them, and they are the basic components of the on which the contract is actually based. Just a second. Furthermore, I would just like to point out that from the DECLA clause, the carrier has absolved themselves from liability. Also, as given in the insurance certificate, the sellers have also excluded themselves from the liability of rusting or any kind of oxidation.
How is the seller excluded?
Mr. Arbitrator, it is given on page number 5 of the Moot proposition that the insurance certificate covers all risks, etc.
Seller is given up.
Please take the question. Insurer or seller? Please take the question properly.
Policy is given by
Have the seller, have the very percent to pay 5% to the seller.
Do you mean to say that the insurance policy is given at the instance of the seller? That is right?
Ms. Abhijita, under a CIF contract, 3 kind of documents are tendered by the sellers. 2 of them are bill of lading and the insurance certificate. The insurance certificate is to cover all claims that the buyer would have if the goods are damaged. The carrier has already absolved himself from the liability under the DECLA clause. Further, the buyer does not have the power of claiming any insurance against rusting as given in the on page number 5 of the Moot proposition, since the insurance certificate has also excluded rusting.
not mean that there is no visible trust from all sides. What happens during the carriage of the goods? There is tremendous amount of rust, tremendous. And when it ultimately is discharged from the ship, it is found to be heavily fitted and in a very bad condition. Would the carrier still be able to absorb themselves from liabilities? Maybe by relying on the regular clause in visible rusting or moisture?
Mr. Arbitrator, the carrier has not defined.
If he is able to absorb himself from all liabilities, then he is exonerated for all times to come.
Mr. Arbitrator, the carrier in the present case has not defined or differentiated between light atmospheric.
No, but let me just quickly tell you, just come to the bill of lading. Just come to the bill of lading. First, page 2.
Yes, Mr. Arbitrator.
Page 2 is the actually first page.
Yes.
It says shipped at the port of loading in apparent good order and condition.
Yes, Mr. Arbitrator.
Which means at the time of shipment. And the red law clause only defines the word apparent good order and condition, not how this is to be read.
Yes.
Right? And it says that apparent good and condition shall not take into account light rust.
Yes, Mr.
Not heavy rusting and anyone in the trade will know that the steel coil will always have a little rust on top or moisture in the spray, whatever. And it is just so that there's no complication when you land at the discharge port and you start a frivolous claim on a small rust, which you can just wipe off and it goes. That's the red law clause and put in. The ship owner has not been exonerated by the red law clause from a proper damage which has arisen as a result of, let's say, leaving the hatch covers open such that salt water has come into the hole, or leaving it freely atmospheric. That is not the case. You reach there and you find there's a rust which is like an inch thick.
Indeed.
That doesn't fall within the red law clause.
I understand.
So, therefore, your argument that you do not have a cause of action against the ship owner because of the red law clause, is that not incorrect?
I understand, Mr. Arbitrator, but the condition that is being put forward by me is that when a carrier has accepted that the goods were shipped in apparent good order and condition, but at the same time he is also claiming that the condition of the goods was unknown, the carrier cannot absolve himself from the liability that he claimed that the goods were actually shipped in good order and condition. Therefore, the carrier cannot deny receiving the goods in good condition, and the same has been done by the carrier at the back of when it has been mentioned at the back of the bill of lading, which says that the goods were shipped in apparent good order and condition, while at the same time the condition of the goods is unknown.
Unless any of our arbitrators have further questions, I think we might say thank you. Do any of my other sister arbitrators have further questions?
Thank you so much, arbitrators. It was a pleasure arguing before this tribunal.
Thank you very much indeed, very much. We are very grateful.
Thank you.
Right.
The council seeks permission to close the dais. May I just take 10 seconds to arrange it? Greetings to the panel of arbitrators. This is Counsel 2 on behalf of the respondents, and I will be mainly dealing with two issues. Firstly, I will establish that how the tender of the insurance certificate was bad tender, and then I will move on to the transshipment issue. In respect to the first issue, I present a two-pronged argument. Firstly, that a CIF contract requires an insurance policy and not a mere certificate, and an unapproved policy is bad tender. Before I begin with the submissions, I would like to draw the attention of the arbitrators to page number 3 of the case study, that is. If the arbitrators may see that it is a mere certificate and it is not the same thing as a policy, as being explained in the Diamond Alkali case, that a policy is a well-known document that comes with clearly defined features, whereas a certificate is an ambiguous thing as it comes with unclassified and undefined by the law.
Can you just enlighten us on one thing? Where is the ambiguity in this certificate?
Indeed, Mr.
Because
Arbitrator.
my own instinct is it's crystal clear what it says, but I'm very open to persuasion.
Mr. Arbitrator, if the arbitrators may see the page, the next page of the insurance certificate, apologies, page 5 of the insurance certificate, there is the mention of the and etc. at the end of the clauses. And as held in the Malberg case,
What is it? Are you talking about Monterey Saccharin?
Under the caption condition, there is a fading, etc.
yes. Also under the Barclays Bank case, it was pointed out that even if the certificate expressly refers to the terms of the policy, yet it does not enable one to clearly understand what the terms of the policy actually are, the buyer has the right to reject it.
Why do we refer to that, the Barclays Bank?
It is given in the compendium on page number 25, and the relevant paragraph has been highlighted.
Are you saying this because of page 3 which says this certifies that the assured is insured under and subject to the conditions of the open policy, and therefore this particular certificate is subject to the conditions of the open policy, which policy has not been received by you? Is that what you're saying?
Indeed, Mr. Arbitrator. Are the arbitrators with me? May I proceed? Thank you, Mr. Also, as held in the Diamond Alkali case, that a buyer cannot become an assignee of a certificate, since there are no legal rights attached to a certificate, as it merely certifies that a policy exists, and a policy in itself is a legal document. Therefore, even if there is express mention that a policy exists, as per the Bombay company case, where it was held that the buyer is entitled to an insurance policy, not a mere assertion that they are covered in the policy and a policy exists.
If you go to page 3, certificate, there is a reference to the policy,
Open policy.
the open policy, and the certificate that is insured under and subject to the conditions of the policy, and this certificate, so read together. Where is the ambiguity of that?
Mr. Arbitrator, may I please contend that, as held in the case of Marburg versus H.J. Evans, it was held that if there are no means of ascertaining the terms of a certificate except by reference to another document which has not been tendered along with the certificate, it renders it to be a bad tender. And if the document is without the convenient reach of the buyers, the present insurance certificate is a bad tender.
But does this certificate not rather skillfully get round the problem which you have very rightly drawn to our attention? Because it says it is subject to the terms of the open policy, provided that the rights of a bona fide holder shall not be prejudiced if the terms of the open policy are different. It then goes on to say, we insure you against all risks. Could I ask rhetorically, what more do your clients want?
Mr. Arbitrator, the all risk that is mentioned is a type A of the ICC cargo clause. And if we see the institute cargo clauses, under general exclusions, it is only mentioned that the inherent vice of the nature of the product can be assured against, and not anything other than that. Whereas in the present insurance certificate, it is mentioned that it excludes rust, oxidation, discoloration, wetting, staining, marring, scratching, chipping, and denting as well, which doesn't come under the inherent vice of these steel coils that are being shipped by the
Before your judgment of the Bombay, the case over there was that there was an assurance given by the seller that I assure you that the goods are covered by a policy. That's not the case here. The seller is actually giving you a certificate which covers the goods, covers the risks, and there's certainty on it. It's very different to the facts of the Bombay. Bombay was just a pure, it's like me saying, the seller, they rang you, like where your whole contract also said, I've got a policy, don't worry. That's not the same thing that will happen here. They're actually giving you that there's an evidence of a policy, that the certificate issued is covering the goods, and therefore if you make a claim, you will get your money.
Mr. Arbitrator, I would like to put forward two contentions. Firstly, in the Barclays Bank, it was held that if the document is not, in the Manwell case that you mentioned, my apologies, it was mentioned that if there are no means of ascertaining the terms of the certificate except by reference to another document, it is bad tender. And in the present case, only the name of the clauses are given. In no case possible, the buyer can actually know what the actual terms are.
But really, it doesn't matter because the buyer is being told exactly what he's getting, because he's being told in the certificate that if there are any unpleasant surprises in the terms of the underlying policy, they won't affect him. I repeat, what more do your clients want?
But at the same time, Mr. Arbitrator, the buyer cannot become the assignee of the certificate, as enumerated in several cases that a certificate is not a legal document, and therefore there are no legal rights attached to it.
I'm sorry, a certificate
You
is
read
perfectly
the second page 3 of paragraph, that page 12, open surrender. That insurance policy, first page.
Yes, Mr. Arbitrator.
The certificate that assured is issued under the subject to the conditions of the open policy, and in this certificate. So what more clarity you want? And the next paragraph, open surrender of this certificate, which conveys the right of awaiting any loss as fully as if the property were covered by very special policy. So what more clarity you want?
And now if you come to the judgment of your Scott and Barclays also, where you highlighted, it was rejected because there was no certainty. In fact, it holds that the result is that when this document is tendered to the client, they cannot tell the reading what the terms of insurance which they are offered. Here the terms have been provided. If you go to page 5, this insurance, all terms have been provided. It's only because there was no clarity that they said that this certificate is not a certificate which is tenable.
Mr. Arbitrator, as the council has already argued that there is an additional etc. at the end of the institute cargo clauses, and the buyer cannot know what all those clauses are, since they are. I agree that institute cargo clauses are standardized, but are all these institute cargo clauses inserted in the certificate, or some of them that creates an ambiguity for the buyer to know what the term of the insurance is actually?
Have a look at the bottom of page 3, the last sentence. This certificate is subject to all terms of the open policy, provided, however, that the rights of a bona fide holder of the certificate. So that is not suggested apart from the seller who has obtained the insurance certificate from the insurance company and has sent it to the buyer. There is somebody else apart from him who might be a bona fide holder of the certificate. That does not suppose that there is in this document is in fact assignable by virtue of the wording the rights of a bona fide holder of the certificate. It supposes that somebody else would be holding on to this document and claiming under the policy. Therefore, does it not suggest that this policy is assignable?
the policy indeed, Mr. Arbitrator, is assignable.
But you just mentioned earlier that it is not assigned.
The council contended that in case of a certificate,
But this is the certificate getting. And it mentions about the bona fide holder of this certificate. So it suggests that it's assigned.
the certificate cannot be assigned to the buyer, as the assured mentioned in the insurance certificate is Central Korea Fabrications Corporation and transferee. So it needs to.
Do you have any case which says that an insurance certificate, assuming that it gives some kind of legal rights, is incapable of assignment? Again, at the risk of repeating myself, you may persuade us, but I think you will have an uphill task. Have you any authority?
No, I don't have an authority that exactly claims that, Mr. Arbitrator, but
The answer is no.
In the case of Diamond Alkali versus Bourgeois, this contention was somewhat dealt with, where Justice McCarty said that the insurance certificate is not a contractual document and there are no legal rights assigned to it. Also, in addition to that, Mr. Arbitrator, he also said that it doesn't come within the definition of policy defined under the Marine Insurance Act.
Did he not say that about that insurance certificate? Was he talking about every insurance certificate, or simply about the insurance certificate in front of him in that case?
Mr. Arbitrator, Justice McCarty was talking about certificates that makes it ambiguous for the buyer to understand what the claims he's covered against.
But you write-up, it says whether the certificate presented in the mentioned case. That was the question put forth by Mr. Jordan. Para 25. Yes, 25, 13 Memorial.
Let me just take 5 seconds.
Please.
Para 25, Mr. Arbitrator?
Yes, you have referred there to Diamond Alkali.
Yes, Mr. Arbitrator.
Please read there, the fourth line. A similar document was presented which said, this analyst present the response of
This
certificate.
This certificate, the word that you need to highlight is the word this. The facts of that case.
Whether the certificate presented in the mentioned case a proper policy of insurance.
But if I may draw the arbitrator's attention to the Diamond Alkali case as given on page 20 of the compendium that is provided. As Justice McCarty cited Wilson Holgate, where it was that the buyer cannot be compelled to take a document which is something like that he has agreed to take. He is entitled to have a document of the very kind he has agreed to take, or at least one which does not differ from it in any material respect. In the present case,
so then you have to argue that specifically that what you had agreed, the kind what you had agreed to take, and that's not your contention here.
That brings me to my next contention, Mr. Arbitrator, that since this is a simple CIF contract and it is implied that the insurance policy must be tendered and not an insurance certificate, the buyer is well within its rights to reject the insurance certificate.
But in this case, is the certificate not as good as the policy? It covers all the terms, but what is lacking in it? That you as the buyer would say, okay, I'm rejecting. Are you not covered? Does it not make specific reference?
Mr. Arbitrator, as the council has already mentioned that this certificate mentions non-exhaustive list of terms, and that makes it very ambiguous for the buyer to actually know the terms of the policy. And since I might reiterate.
Substitute cargo clauses is one, it's a printed form.
This is not ICCA though. This is not ICCA. This policy doesn't have ICCA incorporated.
And that is all.
This policy no doubt, but it doesn't seem to incorporate the ICCA.
And Mr. Arbitrator, for that reason, it makes it all the more reason to reject this document, since ICCA clauses are the highest level of ICC clauses that can be provided by the seller. And we are merely provided with ICC clauses.
You know what the clause
It's all risk. ICCC is not all risk. This is all risk. It says in the all risk. ICCA is the highest form of cover, then B and then C.
Yes,
ICCC is definitely not all risk, but this one says it's all risk. It may in some way, I've not done a comparison, it may in some way differ from ICCA, but this is an all risk cover.
But all risk covered.
Your intention basically is, if I'm not mistaken, I mean, you haven't said it in so many words, that they must be strict compliance with the requirement. That's what you're trying to say?
Indeed, Mr. Arbitrator.
So let me say it in those words. Anyway, go ahead. Please proceed.
The arbitrators do not have any further queries, and since there is a paucity of time, may I proceed with my next issue? Or the arbitrators?
So you'll now turn to the transshipment issue.
Indeed, Mr. In respect to my last issue, which is in respect to the transshipment clause mentioned on the bill of lading, before I begin with the submissions, I would like to just establish and present that continuous documentary cover is a principle under which the seller is duty bound to provide cover from the port of shipment to the port of destination, which was upheld in the famous case of Hansen and Hurley.
I think this board is very happy to accept the correctness of Hansen and Hale. I don't think we need to trouble you to show us that it is correct. The real question is why it's not satisfied here.
Indeed, Mr. Arbitrator, to answer that query, I would like the arbitrators to refer page 35 of the compendium that has been provided. And if I may read to you page 35 of the compendium, Mr. Arbitrator.
My copy has 28.
If I may read to the arbitrators the clause 16, which was pondered upon in the Holland case, that the responsibility of the carrier shall be limited to the part of the transport performed by him on the ship under his management, and no claim will be acknowledged by the carrier for damage and or loss arisen during any other part of the transport, even though the freight for the whole transport has been collected by him. This clause is identical and verbatim to the clause present in the present bill of lading. And in the same case, as can be seen on the next page of the compendium, which is page 36, and if I may read the judge's intention, that a bill of lading with a transshipment clause is not necessarily a bad tender, and that I agree with. But under a CIF contract, it must provide some continuous documentary cover. And a bill of lading issued by a ship owner who by transshipment terms in it disclaims all liability in respect of the goods in the event, and as from the time of the transshipment gives no such continuously cover.
What is such a clause? Is this clause valid in the contract on the bill of lading in front of us? Or might Article 3 Rule 8, either the Hague rules or the Hague Disney rules, it doesn't matter. Might Article 3 Rule 8 be relevant to your argument? Article 3 Rule 8, to remind you, is the policeman of the rules, the rule that says you can't contract out of them.
Indeed, Mr. Arbitrator, under Hague Rules 3, Article 3, Rule 8, such a clause can be null and void, but my contention is that since a clause like this does not allows the carrier to an expansive liberty to transship, it is not a valid clause.
What is your answer to your contention that regardless of this cessation clause and the transshipment clause, at the end of the day, you as the buyer can always pursue the claim for loss to the cargo or the insurance losses. So you're not being prejudiced. That's one of the contentions. Of course, they did face a barrage of questions from us on that. They will try to doubt their proposition. But what is your contention? What is your answer to their submission on this? That your claim against the insurance company is unaffected.
Mr. Arbitrator, it is not only in respect to the insurance claim, but also if the carrier is liable in continuity. Which carrier will be liable is very ambiguous in respect to this present clause. And if I would like to refer to the book that my learned opponent counsels referred to, which is written by Michael Bridge, International Sale of Goods, which is also cited under subheading 4.1.2 of the Moot memorial that has been provided to the judges. And if I may just take 5 seconds and read it out to you. It is contended that a CI buyer is entitled to a through bill of lading. And a through bill of lading is a bill of lading that provides continuous documentary cover to the buyer. So the principal carrier has to be liable for the leg of the voyage that has not been performed by the principal carrier.
And if this clause, if this transshipment clause is ineffective under Article 3 Rule 8, your clients have got all they wanted, haven't they? Because if this transshipment clause is ineffective, the original carrier is indeed liable for anything that goes wrong during the entire transit.
Have you read Rule 8 of the NLUO 3A?
Yes, Mr. Arbitrator.
What does that say?
It says that any such clause inserted by the carrier is null and void.
So then, it's null and void. So then, the bill of lading is fine.
Mr. Arbitrator, I might not have the answer to that, but in the present case, if we assume that Hague rules weren't applying, the transshipment clause renders the bill of lading a bad tender.
Well, that's fine as far as it goes, but I think you have to deal with the question whether this clause is valid, because at present I am inclined to go with my brother arbitrator and say if this clause is unenforceable, then your clients are complaining about nothing.
Mr. Arbitrator, before I answer that query,
Yes, you may.
I would like to ask for an. I would just take 10 seconds to answer.
Which rule applies to this bill of lading?
According to the COGSA,
According to you, which rule applies?
US COGSA 1936 applies to the. According to the general paramount clause given in the bill of lading, it mentions that the Hague Rules enactment of the port of shipment must be applied. But since South Korea is not a party to the Hague Rules, there is no enactment of Hague Rules in South Korea. And therefore, it mentions that in that case, the enactment of the port of destination must be applied. And since the port of destination is Florida, America, US COGSA 1936 would apply.
Where did you get this?
It can be inferred from the general paramount clause that is given in the bill of lading, which is clause 2 of the bill of lading.
Does it really matter which version of COGSA applies anyway? Assuming some version of COGSA applies, Article 3, Rule 8 is in precisely the same terms in all the relevant variations of COGSA. So I think you still have to answer the point. Does Article 3, Rule 8 in this case nullify the transshipment clause?
I'll just take 5 seconds and actually read Article 3 Rule 8 and answer that to you, Mr. Arbitrator. In the case of Mayview Foods versus OCL, it was held that even though the contract expressly provides the carrier with the option to transship, he will remain fully responsible under Article 3 of the Hague Rules for the safety of goods under the transshipment period. Hope that answers
Well, that
the
goes against you.
So that's the reason why.
That's exactly what we're saying. Therefore, your bill is good. There's nothing wrong with the bill.
If it's referring to Article 228, then that particular clause, which is attempts to contract the carrier out of liability for the second leg of the voyage, then what my brother judge is saying, the arbitrator is saying, is that bill of lading is fine, because that portion gets knocked off.
Mr. Arbitrator, if I may try and answer that query of yours, since this is a contingent bill, and even though the facts are silent on the fact that whether a charter party exists or not, this bill of lading.
There's a clarification. There is no charter party. In your queries, the answer is very clear. Is there a charter party? No.
The bill of lading was issued subject to any charter party that might exist, but there isn't one. So I think that's something which you can just get rid of.
I just have 1.5 minutes left, Mr. Arbitrator. So if I may just proceed.
You may have another extension after this one.
Go back to again, Mayview Foods versus OCL. I think that page 20. So that your argument is little bit more nuanced for us. Page 20. You are saying it is humbly submitted, you are saying that carrier is being relieved from liability.
Yes,
The
Mr.
clause is violative of Article 3 of the rules.
Yes, Mr. Arbitrator. Sorry, Mr. Arbitrator.
So to the question raised by my learned brother, arbitrator. So like so that actually the carrier is being relieved from liability.
The Article 3 Rule 8 mentions that a benefit of insurance in favor of the carrier or similar clause shall be deemed to be clause relieving from the carrier from any liability. And since this clause is providing the carrier with the benefit, it disclaims all liability under. Also, since this is a CIF contract, it is imperative to understand that the insurance certificate and invoice and the bill of lading are essential to the terms of a CIF contract, and the seller must comply and tender those documents in proper condition.
So strict compliance.
Might you,
That's what you're saying.
might you wish to argue on the point whether the Hague or Hague-Bisbee or whatever rules they are applicable by force of law or only by contract? Might that be relevant to your case?
Mr. Arbitrator, the express intent of the parties definitely prevails over the general paramount clause, and it is not enforceable by law. It is by the express intent of the parties that these rules apply. And it is nowhere mentioned that it was the intent of the parties to actually apply Hague rules, and also this is a standard bill of lading, and as my opponent counsel already argued that this is a draft copy. So it does not in any way express the intent of the party.
What we were draft?
With the draft copy, how will you have got delivery of the cargo and it arrive at the destination?
Oh.
And the rest of the draft copy, how will you take the delivery of the cargo?
Sorry, Mr. Arbitrator.
This is a draft copy of the bill of lading.
Well, then should your argument actually should have been that draft copy has been provided. That is why we rejected the
But it's a draft copy, you cannot take delivery of the cargo on presentation of a draft copy of a bill of lading. You need to credit the original. Bills of lading are issued in 3 sets. If one is surrendered or produced for delivery of cargo, the other 2 stand void. This is just a draft copy. You never got delivery.
Yeah, even if I leave that argument, Mr. Arbitrator,
You can proceed to the next point because we have limited time on hand now.
yes, Mr. Arbitrator. Though I could not satisfy the panel of arbitrators on whether what rules should apply.
No, you can make a point. Please make a point on the you.
I would just like to contend.
Raise the point.
I would just like to contend lastly that the carrier is clearly limiting its liability under this clause, and as similarly held in a number of cases, that such a clause limits the liability of the carrier, and also held in the Socroma SPA case that any clause that provides the carrier with the expansive liberty to transship does not provide continuous documentary cover, and that makes a bill of lading under a CIF contract bad tender. If the panel of arbitrators do not have any further questions, I would just like to briefly mention the prayer, and then the respondents respectfully like the panel of arbitrators to declare, in the light of the facts mentioned and the arguments advanced, to declare that there should be a sole arbitrator and disallow summary disposal, and declare that the insurance certificate and the bill of lading are non-compliant with the terms of the contract, and we seek an award that renders to justice, equity, and good conscience.
But the first two is allowed.
Exactly.
Third doesn't come in. You can either choose sole arbitrator and secondly no summary judgment. Then you can go for a full trial. Or you're saying that you agree there should be summary judgment and you need your summary judgment.
If it's a sole arbitrator, we can't get it.
Indeed, Mr.
The
Arbitrator.
sole arbitrator has to decide it on that. So in the event we hold against you on that issue, only then can you get to the list. That's an alternative arbitrator. If you are against it on the law,
Alternative
then in that
is
case,
what you need to
Yes, I agree. I made a mistake there, Mr. Arbitrator. Thank you. It was a pleasure arguing before the panel.
thank you.
Very much indeed.
Is there a rejoinder?
Yes, sir.
Yes, sir.
So the teams have reserved their times out of the total time of 45 minutes for rebuttals and surrebuttals.
So that's over then.
No, so they have reserved extra time for the same.
Okay, so how much time do they get for the rejoinder?
So the claimant has reserved 5 minutes and the respondent has 3 minutes.
That's the sum of the rejoinder. All right. Only one speaker or both of you will speak for 5 minutes each?
No, even one speaker suffices.
Why do you want to be the only speaker?
Yes, I will do also record.
Why?
Yes. Firstly, on the part of, I will revert the respondent on the part of arbitration. Firstly, the respondents need to understand that the element terms that we agreed upon in terms of the arbitration agreement. We specifically make a mention that the element terms have been incorporated in the agreement. That is essentially the element terms and terms of the agreement. So in the agreement, when they agreed to go into 11 ICP, if you go to ICB, the respondents cannot come here and then deny that we have not agreed upon the same thing. The LMA terms incorporated in the survey terms of the contract. Further, the written submission of the respondents, they clearly make a mention that they have come to the arbitration under the bill of lading. That is completely not in accordance with what they have submitted in their own submissions. Further, going on with the.
But you want to get the arbitrator.
Yes, definitely.
You don't need to bring up what you just brought up is that there's no arbitration, there's no jurisdiction. Because he's saying bill of lading, you're saying sales contract. You're the claimant. You want the arbitration to continue.
Yes. Further moving on, I would like to make one clarification regarding that there was hold an arbitration agreement that both the arbitration panel held. On the fact sheet page number 1, on fact sheet page number 1, it specifically mentions that on call they agreed to the sale of 220 metric tons at the price. Further, it says that the terms were CI. Now, this breakage in the sentence further was the terms under 5 sheet evidences that the written contract was made. Since the terms of CI were agreed.
Well, now we need to move it into evidence. So, summary judgment may not be allowed. Because you're now dealing with facts of how the contract came into being. So we need to have a full trial with evidence being led. How can we decide on something?
On the particular
on this issue.
The only thing that the condition I'm making is that agreed by telephone, then the terms of sale were CIF Miami. Also, the terms were recorded. It essentially says that if the terms are recorded, then there is essentially some kind of written evidence is there, and therefore the arbitration agreement is valid. It is a written arbitration agreement.
So where is it? You're the claimant. Prove it.
Pardon?
You're the claimant. So
how?
Where is the written arbitration agreement? How do you plan to prove it? You need witness evidence. He's saying it's oral.
They are not considered about it. That's oral or not.
You must get the hint. Actually, you don't read to a situation where you have to answer that or you have to prove that.
Sometimes you let go of things for the betterment of
you have to go off things. And that's a very good strategy.
Indeed. I won't enter into this. Coming to the insurance certificate, they say that the insurance certificate is not exhaustive. So here, the mere contention is that there is the presence of etc. Now this etc. It is insurance subject to the following institute cargo clauses. Now the institute cargo clauses are exhaustive in nature. They are publicly available, and since so the cargo clauses that are there are essentially
illustrative. The point is that it is illustrative.
It is illustrative.
Initially, to start with, it is well documented.
Yes, it is well documented. So the point of the respondent that the insurance certificate is ambiguous and therefore not a good tender is completely invalid. Further, moving on, this certificate is not assignable.
Arbitrators were actually there was a bunch of questions and what more you want regarding the insurance also. Yes.
Yes, I will further move on to the point of Ratho clause. Now here the claimants have tried to prove that Ratho clause is merely making a clarification with respect to the condition of the goods evidenced by the words apparent order and condition. If it is a clarificatory clause, it cannot take the nature of clausing the bill of lading. Because if a qualifying clause is there for apparent order and condition, then only the bill of lading will become unclean. If it is merely providing a clarification, then it cannot enter bill of lading unclean. Further moving to the Sekhar clause.
Is it okay that Ratho is not a part of the clausing?
Yes, Ratho clause for a bill of lading to be unclean, a qualifying clause must be there. Ratho clause is a clarificatory clause by the
do you have any case law which says the difference between clarification clause being not keeping a bill of lading unclean and
I don't know the reasoning. I don't know the case law, but from the reasoning. On the basis of Saga, I was making the case simply because in the Saga Explorer it said that evidence, if the if that particular clause is giving prima facie evidence, of what the case, what the condition of the goods at the time of shipment, and if the carrier and the seller, if they cannot go back on their terms, then the claimant still can proceed against both of those, even the ship owner in that particular case. This is a master. If he makes certain kind of, if he deviates from what he has said, then the claimant can go into under the bill of lading. So since it's a merely clarificatory clause, and after Saga Explorer, the clarification is merely with respect to visible justing, and therefore it is not a qualifying clause, and therefore it is a clean bill of lading. The last The last point was only with respect to how the existence of mere.
Okay, no, I think you have completed.
Thank you.
Arbitrators, if it's possible, we have reserved a total of 3 minutes for the rebuttal. Would it be possible for both the speakers to speak one after another on the issues that we have dealt with in our?
You can distribute 1 minute for you and 2 minutes for you. I don't think you like.
Arbitrators, I would be discussing 2 rebuttals that happened.
Because you have not exhausted much of your time, so we give you 3 plus 3 minutes. Alright?
Miss Arbitrators, I would be discussing 2 issues, 2 rebuttals that have been pointed out by the claimants. The first was whether in the first one they pointed out that the parties had agreed to the governance of eliminating rules in the arbitration clause. It has already been mentioned in my speech that the inclusion of both English law and LMA terms brings a lack of express choice in the arbitration agreement, and therefore the implied choice of law of C would be applicable since there is no mutual consent in the present agreement. Secondly, they have mentioned in the issue of reclam clause, they have mentioned the case of Saga Explorer, in which I would like to point out that the goods were actually rejected by the buyers, and that was allowed by the court because there was an ambiguity in the sense that a condition of the goods was mentioned to be unknown by the in the bill of lading, while at the same time it was also mentioned that the apparent condition and apparent order and condition of the goods was good. Therefore, that created an ambiguity for those who were relying on the contents of those on the bill of lading, and that was rejected by the buyers, and that was upheld by the court. Therefore, the whole contention which the claimants provided in view of the Saga Explorer case does not have any value. Thank you.
Arbitrators, in the concern raised by the claimants in respect to the insurance certificate, that our contention merely relies on the phrase etc. and that does not render that tender. I would like to put forth just 2 contentions and briefly summarize it. I would like to walk you through the case of Malware versus LJ Evans, where it was held that if there are no means of ascertaining the terms of the policy except by reference to another document and which has not been tendered alongside, the policy has not been tendered alongside the present insurance certificate and is not within convenient reach of the buyer, and therefore, as per the rule laid down under this case, it renders it a bad tender. Also, as mentioned by my learned opinion counsel, that the insurance certificate is covered under ICC Institute cargo clauses. I agree, but since it mentions etc. at the end, what it tends to do is it makes it ambiguous for the buyer to know under what ICC clauses the buyer is covered under.
A, B, or C.
Indeed, Mr. Arbitrator. Also, it makes it a non-exhaustive list of conditions. What it does is that since there are a lot of ICC terms, the buyer cannot ascertain as to what terms exactly the buyer is insured against, and if there are all the terms of the ICC or some of them. Hope that the query is answered. Yeah.
With this, we conclude the intense final rounds of the 10th National University Bose Mitra and Company International Maritime Arbitration Moot 2023. I thank our esteemed panel of arbitrators and the participating teams. We shall be taking a short break and thereafter starting with the valedictory ceremony at 8:30 p.m.